So everybody, thank you for coming to this privacy talk. I'm a great honors to invite Isabelle from Belgium. So she's very great to work at the data protection field. So Isabelle, thank you for coming this moment.
With pleasure.
Thank you. So I'd like to introduce her profile. Isabelle Vereecken is head of Secretariat of the European Data Protection Board. The EDPB Secretariat is in charge of drafting EDPB documents, providing IT solutions to ensure transparent communications between all the European national data protection authorities, handling EDPB media relations, as well as organizing all EDPB meetings. She is leading the Secretariat from the beginning of its existence. Prior working for the EDPB, she was a legal advisor at the Belgium Data Protection Authority for 10 years. In this position, she was in charge of international data transfers matters, and she regularly contributed to the work of the Article 29 Working Party. In addition, she followed closely the negotiation of the General Data Protection Regulation, being attached at the European Commission working on the proposal, and after by acting as an expert to support the Belgian government during the negotiation. She started her career as a researcher and worked at the CRID, Computer and Law Research Center, University of Namur, on data protection, intellectual property rights, and e-commerce issues. She has a master's degree in law from the University of Leuven-la-Neuve, Belgium, and a postgraduate degree in ICT law from the University of Namur. So thank you for having this conversation today.
With pleasure.
Thank you. I'd like to start the first agenda with you. So you have been involved at the data protection for your career. So why did you get interested in this space?
Yes, in fact, I'm coming from a family where the computer have already been present already in 83, 84. So I was interested by ICT law also during all my studies in laws, making legal analysis, for instance, of the value of emails as evidence or paper on conflict of domain names or on the liberalization of the telecommunication law in Europe. And so after my legal studies, I decided to start an extra year in Namur in ICT law. And I met an amazing teacher, Professor Yves Poulet, who launched this research center, CRID, already in 1979. So that was really early. He was specialized in data protection, and he understood the risks and challenges posed by this subject matter way before the others. After this extra year, he invited me to work with him in the research center. And I started my career on data protection, but also on e-commerce and intellectual property law matters. And I first thought that data protection would be a bit too small as a legislation, because at the time in Belgium in the directive, it was not so many articles like in the GDPR. And I saw that maybe it will be, I will be, I don't know, bored if I just make data protection. But I quickly realized how indefinite maybe all the questions that can be posed, depending on the sector you apply them. And so after this experience, I moved to the Belgium DPA, the Data Protection Authority, as you said, and then I was working there for 10 years before moving to the European sphere.
That sounds very interesting. So you are now taken in charge of the very significant role at the European data protection as a EDPB. So could you tell me about your missions at the EDPB? So what is their commitment in this organization?
Yes, thank you very much. So the first goal of the European Data Protection Board is to provide consistent interpretation of data protection laws in Europe, meaning that they would apply in the same manner, whatever the countries, whatever the authorities, whatever the situation. We have four large area of competencies to meet this goal. First, we provide guidance and recommendation to ensure consistent interpretation of the European data protection laws, so GDPR, but also law enforcement directive. And we address the public sector, the private sector, and also the data protection authorities, which are making reference to our guidelines in their decision or national guidelines. Up to now, we published 57 guidelines and 6 recommendations to increase the legal certainty in the application of the GDPR. Last year, we adopted, for example, 14 guidelines on topics like personal data breach, code of conduct as a tool for transfers, or virtual voice assistant, or the storage of credit cards in the context of online transactions. Um, and recently also we issued guidelines on the cooperation mechanism between the authorities and on the calculation of the fines. The second big area of action is to ensure this consistent application, but with some opinions and decisions which are addressed mainly to our member, the data protection authorities in Europe and in the European Economic Area. We adopt opinion when the authorities, they have a competence to adopt a decision or to adopt an approval. For instance, they approve binding corporate rules or code of conduct or certification mechanism. They are making a list of the processing that have to be subject to data protection impact assessment. And before being able to finalize the decision or the approval, they send us the draft and we make an opinion on those drafts to ensure that in all countries, BCR will be evaluated in the same manner, the code of conduct also, and the processing that will be considered as risky and being subject to DPA, so data protection impact, will be likely to be the same or consistent in the whole Europe. So, for example, only on last year, we adopted 35 consistency opinion on those draft decisions. So that's really like a maestro with an orchestra where we provide consistent application to the authorities and to ensure that they will apply and adopt decisions that are consistent. Another big area in this one is the binding decision. So it's not opinion, but binding decision that are legally binding on the authorities and which relate mainly on enforcement activities. So in enforcement, when a subject matter, for instance, there is a company having a processing activities and there is establishment in different member states, different countries in Europe, um, or the citizen, the individual that will be affected by this processing are coming from different countries in Europe, then there is a duty for the authorities to cooperate between each other with a system which is called the one-stop shop. There will be one authority that will lead the process, and all the other competent authorities, we have a right to comment the decision and to work together. There is a possibility to raise objection for those competent authorities if they disagree with the proposal made by the lead. And if they cannot manage to find an agreement and to reach a consensus, they have to go to the ADPB that will make a binding decision that will be in fact addressing the lead supervision authorities and making eventually requests to change the draft decision on the basis of the objection or not. In practice, this cooperation work by the authorities is made mainly outside the scope of the EDPB, and we are not called to take regularly binding decision up to now, because you can see that the data protection authorities have dealt in total with more than 2,000 cross-border cases, and they adopted 300 80 final decisions which have been taken alone without the intervention of the board, and then in few circumstances there are already 3 binding decisions that were adopted by the European Data Protection Board. I try to count correctly. So it's the Twitter, WhatsApp, the second WhatsApp, and Accor. Yes. So it's only in a few situations that they cannot manage to reach the agreement together that they go to the European Data Protection Board. The third main area is when we give legal advice to the European Commission. The European Commission, is in charge in Europe to draft legislation or implementing act that will be after negotiated with the European Parliament and the Council. And when the matter is important for data protection, the board is giving an opinion. An opinion that is famous, I think, for you is the one relating to adequacy findings, like the one we made on the Japan adequacy finding. Or there is also a possibility for the European Commission to create standard contracts. It was quite famous that they made a standard contract, for instance, for the international transfers of data, and we made opinion on that. Or on the new legislation, like the one relating to the new data strategy. The last area, which is increasing of importance, is the support of enforcement. So the enforcement is really the role of the regulator, the national regulators, the authorities which are making investigation and adopting sanctions. And the board, nevertheless, we decided to support this action because we can see that there are some difficulties that are facing by the authorities, and we find all the means possible to make their life more easy and to facilitate this enforcement.
Yeah, sounds very good. And also that you do a lot of the work on your team, then that's a very enormous actions to protect the consumer rights. So that's pretty interesting. For us, such as data protection expert, is try to take a reference from the EDPB guideline, which is a very informative to understand of the situation, not just only for the European, but also some other regions, such as in Japan or other Asian regions, is try to take a reference of the EDPB publication. So how GDPR guidelines is being prepared within a EDPB and published to any data protection experts?
Yes, so in practice, the guidelines are first prepared in, as you said, in the EDPB expert subgroup. So how we work, there are different subgroups with different subject matter. For instance, on international transfers, there is one subgroup, or on question of law enforcement, there is another subgroup. On those compliance matter, like the accountability tool, the BCR certification, not the BCR, the certification and code of conduct, there is another subgroup also being charged. And those subgroups are preparing the work. They are the technical discussions for the preparation of the document. And then after it reached the level of the plenary meeting, where there are the decision made by the head of the different authorities. In practice, for the guidelines and all the document of the board, this is like a collaborative work. For instance, the EDPB Secretariat works a lot on all those consistency tool, so the binding decisions and the opinions also on BCR certification, etc. Because we are an independent party, because we cannot be one of them that are proposing a draft decision. So, and we have a perspective of having the capacity to see all the draft decisions which are coming to us. And so for this consistency, the Secretariat has a main role. Then for the guidelines, it's a bit more shared. Sometimes we are taking the leadership in the Secretariat, like for the recommendation on the supplementary measures. But in most of the time, it's member state staff member which are leading the drafting. So there is a call for rapporteur at the beginning of the process when there is a mandate for a new guidance, and different member states can decide to contribute. One will take the leadership normally, and the other will prepare the draft. So sometimes we have drafting team preparing together in a small group a first draft, and then after it goes for discussion in a subgroup and meeting, and then after going to the plenary. So in practice, if you want to know also the size, a subgroup, you can have easily 50 people taking part in a subgroup. And in the plenary meeting, it's more meeting of 100 people for taking the final decisions on the documents. In practice also, to also give you an idea of the size of the and the workload of the EDPB, for instance, last year we organized 400 meetings. So this, if you count the number of working days, it means that every day there are at least one meeting, and in normal even several meetings of the EDPB taking place at the same time in parallel. So there is an intensive collaboration to this work for having guidance and document published by the board.
Wow, the EDPB that works so many things, and not just only for the binding, but also like the collaboration. That's been a very significant process to organize the data protection lead. So I'd like to move to the next questions. It's about the very interesting topics for me, because I was lucky to visit the EDPS conference there. A lot of the member states is talking about the Vienna discussion. So could you tell us about this Vienna holding? That's what's happened, what's the decision, what we'll be expecting to change through the EDPB perspective?
Yes, with pleasure, Kue. So so the chair decided to invite all the members a bit outside of the plenary, because in the plenary we have many documents to adopt different topics, etc. At the same time. And the idea was really to focus on the question on enforcement of the GDPR and to see what are the challenges and what we can do to support and to promote enforcement of the GDPR. And so all the head of the national authorities have been invited by the chair in Vienna in April during 2 days to discuss this enforcement cooperation and to see how it can be further enhanced. It was really a great momentum for the authorities, and they agreed on a series of measures. There are, I will focus on the 3 main outcomes that were made to improve enforcement cooperation. The first one is the closer cooperation on cases of strategic importance. So the authorities decided, this is coming also from the experience of the one-stop shop and also the discussion that we also had in the framework of the guidelines on the one-stop shop. This is Article 60 of the GDPR. We realized that it was necessary sometimes to go even beyond what is described there. So having the cooperation of the authorities when a draft decision is there is in practice a bit late. So what is needed is to have a more earlier exchange between authorities and more comprehensive exchange between authorities from very the beginning of the enforcement investigation and work. So the authorities in Vienna agreed that they will select some case of strategic importance for which they will really decide on an action plan for having a small group of authorities that will work on that strategic case with an action plan with a concrete timeline to ensure the swift progress of the investigation and to report on that. At the plenary of the 12th of July, so just recently, 8 days ago, DDPB made further work on that agreement, Vienna agreement, and we have adopted the criteria for making the selection of the strategic case, also the process to follow. And they also decided already on the first cases that will be considered as being strategic. They will be further in September, October, but they already identified 3 of them. The second big decision taken in Vienna was to align the enforcement, the national enforcement strategy. So most of the authorities at the beginning of the year, they decide what will be for the next year the national enforcement strategy. And the idea was to work more at the EU level to develop some items that could be European ones. In fact, we have this experience of I don't know if you heard about this coordinated enforcement framework. That is already an action that we made, where we decided that once a year we will select a topic of enforcement and we will make it together at the board level to create a joint investigation and sweep activities. So the first one was the use of cloud computing in the public sector, and where in which 20 authorities work together. And we realized that the impact of EU-wide investigation in enforcement is much higher than when each DPA's authorities are working separately, individually. So we want then to have this annual enforcement priorities at European level. And then the last block of decision in Vienna, the last big one, is to try to remedy the obstacle created by procedural law, because so in the GDPR, you have rule for cooperation, but in practice, every authorities at national level, it's an administrative authorities, and they are subject to their own national law for administrative law, to put in place their decision. And we realize that those aspects of legislation are not always for sure harmonized because it's a national matter, but we realize that maybe we can try to improve the harmonization on those questions to foster the cooperation of the GDPR. So the idea is to collect the topic and then to make a proposal to the European Commission in October, to make a request for them to intervene in this subject matter, to foster, to create more harmonization in those um, area of legislation.
Thank you. I think that in a Vienna conversation will be accelerating of the new enforcement things. I've been feeling it in visiting to the conference. That was very amazed. A lot of the experts are talking, discussing many things for the future. So that could be the very expecting from my insight. So to the next question is about your topics. I was lucky to be a part of your speaking session. Then you accorded one good use case about the WhatsApp, the privacy policy decision. Could you tell us about the details of this decision for that?
Yes, so this is one of the binding decisions. So I think it was the Article 65 binding decision on WhatsApp that we adopted last summer. So in practice, it's an example where the EDPB had to intervene to settle the dispute between the authorities on an enforcement action. So WhatsApp, the lead supervisory authority for WhatsApp is the Irish one, the DPC, and they launch an investigation on the transparency aspect of WhatsApp, the respect of transparency measures in their privacy policy. And they propose a draft decision to the different authorities, and several of them raised objections and said that there was a need to make some change in this decision. And despite their conversation, they didn't manage to reach an agreement. So at the EDPB, we intervened in that. And so in practice, it was the Secretariat that was leading the work. So what is the work in that one is to first assess if the objections that are raised by the authorities are reasoned and relevant, because they need to be motivated and need to meet a certain threshold put in the GDPR to enable us to be competent to assess the matter. And then after, we went into the merits, so the content of the decision. So in practice, what was the consequence on that is that the EDPB requested the Irish SA to modify its decision and to consider that there were additional breach of GDPR, that more articles were breached than the ones that were identified by the Irish SA. So it was Article 5, I think some article in transparency. And we also discussed the method for the calculation of the fine, because in the draft decision in the initially by the Irish essay, there were so several infringements, but they took the gravest infringement and only find that one. Well, in fact, we said that we should add, in fact, we should, yes, consider all the infringements, and so the fine had to be increased. So we asked the Irish essay, the Irish authority, to reconsider its decision, to change the decision, but also to increase the level of the fine on the basis of the new method of calculation of the fine and the new infringement. So in practice, WhatsApp initially was in the first draft, they were supposed to receive a fine of 50 million euro, and the Irish authority, following our decision, decided to impose 225 million euro on WhatsApp. So that's the decision which has been taken. In practice, WhatsApp is making an appeal against that decision in front of the Irish court, but also in front of the European General Court. So we are working right now we prepare the defense, etc. So everything, the written part will be soon closed, and then we will see what will happen. But it's a very interesting activity, because it's the first time we will have litigation at the board level, and we are quite confident for the future.
Yeah, I think it's very challenging, but you're competing, not just competing, just being challenging to the against of any infringement of the consumer. So that's gonna be a very interesting actions in the European level. That should be very significant to the other regions as well, because those kind of the big tech business is not just one single countries, but widely to be spreading the business all over the world.
Yes, you're right. It's a very important matter for all over the place. We can realize this when we take part to the GPA meeting, the Global Privacy Assembly, and we see that those kind of same question happen all over the world for those companies. The fact that in Europe also in the past, in my beginning of life on data protection was more a matter where it was subject to opinion, recommendation, etc. It was a bit a soft law, I would say. There were few case law, and following the GDPR and the capacity of the authorities to issue fines, we can see a clear movement to go into I would say a more I would say an area of law which is already also subject to many case law, so more legal certainty also for the business, a bit more like competition. But competition, it's already 70 years of experience, and for us it's only 4, sorry. But it's very interesting to see that, and it's totally part of the work to also have to go to court and to defend the decision that we are taking. So that's why we are taking all the measure to take the robust decision that can stand in front of court.
Awesome. So I move to the last question. It's just kind of the future landscape. I'm very inspired since on the conference that many stakeholders is coming to one place. There is very important from the Japanese perspective, because I haven't never seen like that, because in European has been discussed those kind of the issues almost being started the GDPR. So could you share about the future directions of the EDPB? Maybe you have some ideas such as in certifications or any other operation effectiveness that is in also the challenges in EDPB or other European stakeholders. So could you give us your EDPB the landscape?
Yes, for sure. So in practice, the EDPB at the beginning of the GDPR and the application, we made a lot of guidelines to explain, the key concept of the GDPR, and to provide a clear interpretation of the GDPR for the particular sector. We will still continue on that, but right now the focus of the EDPB is a bit moving on enforcement, support of enforcement, and also those accountability tool, as you said, because the ultimate goal is compliance. So I work myself a lot on the binding corporate rules, and these are co-regulatory tool, because in practice we are setting the criteria, but then the company is meeting the criteria, and then there is a discussion and with the authority, which is checking that everything is compliant, and then after the binding corporate rules is approved. In the GDPR, we have those new other tools of accountability tools that have been created, the one of code of conduct and certification. In practice, the GDPR does not go into very much detail on how the framework should be created. So was a lot of margin of maneuver for the board to create everything from that point. And then the European Data Protection Board from the beginning made a bit it's a bit less, I would say, known by the public, but we created really the scheme for being able to put in practice those tools of code of conduct and certification. So we published guidance. We also reviewed all the authorities, they have to give accreditation to private company that will provide certification, that will issue the certification. Or for code of conduct, you need to have a monitoring body that will check that code of conduct are respected. There are also private companies. And the regulators in national level, they have to accredit those companies and to issue the criteria to accredit those companies. And we receive from all over the EU countries the draft certification accreditation criteria, and we ensure consistency to be sure that if there will be a certification company giving certification in one member state, it will be under the same rules and same conditions in another countries in Europe. So the framework, it's a bit the institutional framework that was created, and then on the side also creating the conditions or the criteria to meet what should be incorporated within certification scheme or in the code of conduct, as we did for the BCR. And so we developed this. There will be an area for using those tools inside Europe. So for companies that are subject to the GDPR and wants to even have on the top of that a certification or a code of conduct. But these tools can also be used for international transfers. So that's the last action that we did, is to publish guidance on the use of code of conduct for international transfer, and very recently the one on certification for international transfers. So we are shaping this, and I think that there is a huge interest from the business to make use of those tools. So when everything will be finalized, and it's already starting, we are receiving draft of code of conduct, draft certification scheme, etc., that we are evaluating at European level, etc. So there will be a lot of work also on that field, which is good, because it's always also interesting to see the interest of companies to develop their own mechanism to be compliant and to ensure that it will be put in practice, that it will be not only contract being signed, but put in place, tools inside the company, like training program or complaint place, a DPO team, etc., to ensure that this becoming live, the protection within the company.
Thank you.
And of course,
Please.
we will have still a lot of binding decision, I think, because as you said, the enforcement is really ramping up. There are more and more decision made at national level, and so even if we have a small proportion reaching us, this is increasing, and so we will also have more binding decision coming for sure.
Thank you. I think a lot of companies are trying to exploring what is the best practice, but I think that your message is just that your company should work on your own practice for the consumer protection, the data protection. That could be very important. The company should consider themselves what is the best practice, and sharing to the best practice to the other companies to combine in the best operations for the data protection. That's going to be the great actions, and I'm expected the new actions from your organization. That could be a great reference for the company.
Yeah, data protection can be definitively a competitive advantage for the business. And we can see that we saw that in the BCR, binding corporate rules sphere, when as from the moment there is one company in a particular business, like in I don't know, pharmaceutical or petrol company, then all the competitors want to make it because they want also to show to their clients and to their consumer that they are also paying attention to that. And so, yes, it's important because at the end of the day, you cannot make business if you don't have the trust. The trust is key for business, and also in a environment when everything is digital, etc. So it's really important to try to be ethical and to gain the trust of your consumer.
Yeah, absolutely. So could you give us any last message from your perspective? Because I think a lot of the companies or individuals should work for the privacy and data protection at this moment, because it's a digital surgeon that we should be changing the environments for the direction. So could you give us your message from your insights?
Yes, first, I would like to thank you very much, Kue, for having invited me today. It's really a pleasure. Also, considering this mutual adequacy findings which has been done between Europe and Japan. And that was in fact the first agreed mutual recognition of the adequacy, which is really good in my point of view. So the data flows are made more simple between the countries. So that's also very important to underline. And I think that it's important that if the business is there to take into consideration that investing in privacy is not a lost investment, because it's not only about paying attention to the risk and looking at the price that you can pay in case of infringement, if there is an authority that will catch you, but it's really to try to distinguish yourself from the other, to try to avoid breach, because you can see that even a very important company can quickly lose a lot of profit and income from the moment they lose the trust of the consumer. So it's important to take this into consideration and to take privacy seriously.
That's a great message. So again, thank you for having Isabelle in your precious time to giving us. Then yeah, that's very exciting to collaborate it to create new things for the data protection and trusted world. So yeah, again, thank you for having this time.
Thank you very much. Yes, data protection is becoming more and more global. So for sure, there will be always work in that field all over the globe. Thank
Thank
you,
you.
Koi.
Thank you.